Hello, everyone. We're going to begin today's program. I just want to thank you for joining. My name is Akira Arroyo. I'm the director of the Neighborhood Entrepreneur Law Project at the City Bar Justice Center. And again, thank you for joining today's webinar on commercial leasing considerations for small business owners in light of COVID-19. The Neighborhood Entrepreneur Law Project, or NELP as it is more commonly referred to, has been providing legal assistance to low to moderate income micro-entrepreneurs hoping to start businesses in New York City for nearly 20 years now. Next slide, please. And during that time, we've assisted over 15,000 entrepreneurs and small businesses and have worked with volunteer attorneys from over 100 different law firms and corporate in-house legal departments to deliver these services to individuals who saw entrepreneurship as a means of creating economic stability for their households and communities. Typically, we assist with issues such as entity formation, commercial lease reviews, contract drafting and reviewing, and intellectual property right protection. However, today with the COVID-19 pandemic, we, like many small businesses, have also had to pivot and change our business model and focus. Previously, the bulk of our programming took place out in the community in places such as libraries and solution centers. And now, as a result of the outbreak, we have moved towards an online and remote model of delivering pro bono legal services, which has resulted in the creation of the City Bar Justice Center COVID-19 Remote Small Business Legal Clinic. Next slide. Through our remote clinic, business owners can sign up on our website, www.citybarjusticecenter.org, for a 45-minute limited scope legal consultation with pro bono attorneys who are trained to assist business owners to better understand and act upon the federal government stimulus package, as well as other opportunities available through federal, state, and local programs. Small businesses can also ask questions about other issues such as contracts, employment law matters, commercial leasing issues, and insurance matters. Our focus at present has shifted to working with already established businesses to try and help them remain in business and get through these difficult times. To that end, in addition to our remote legal clinic, we are hosting presentations like today's geared towards addressing common issues impacting small businesses. But before we begin today's program, I'd like to thank the Brooklyn Small Business Development Center for co-sponsoring this event with us and for being a constant source of information for New York City's small businesses. And most importantly, I'd like to also thank the law firm of Kirkland Ellis, LLP, for partnering with NELP and the City Bar Justice Center on our COVID-19 Small Business Initiative and remote legal clinic. Without them, none of this would be possible. And for putting together today's webinar on commercial leasing considerations for small business owners in light of COVID-19, I want to thank our speakers, who I will introduce in just a moment. But the program today is something that's obviously on everyone's mind. It's a very timely and important issue. And our volunteer attorneys today are going to address and hopefully answer some of your concerns and shed light on some of the options available with current circumstances. So attorneys from Kirkland and Ellis will provide an overview of certain noteworthy commercial lease considerations targeted to assist small business owners in navigating risk identification, rent relief, and strategic options in the COVID-19 environment. Additionally, if time permits, the presentation will be followed by a brief Q&A session, but I ask that you please limit your Q&As to our chat feature for now. And we will try to address issues as they come up. On a housekeeping note, we are recording today's program, and we hope to circulate a link to all participants with the recording and slides in the coming days. Additionally, an email with a brief survey will follow the presentation, and we ask that you take just a few moments to answer 5 or 6 brief questions for us. And again, as mentioned, we will try to reserve a few minutes towards the end for additional Q&A, which you will have to enter in the chat box. We have one of our speakers who's actually manning that chat box throughout the program. So if your question isn't answered in the chat box, it will be answered hopefully afterwards, time permitting. So with that, I'm super pleased to welcome Justin Elliott, Thomas O'Connor, and Samuel Steinman from the law firm of Kirkland and Ellis. And now I'll turn it over to the Kirkland team. Thank you.
Thank you, Akira.
Great.
This is Justin Elliott. I just want to thank Akira and her whole team. You know, I don't want to be duplicative, but we appreciate the opportunity here, and also want to say hello to a number of our participants in this function who I have already previously had the pleasure of speaking with. So hope you're all doing well, and apologies in advance if this is duplicative of anything we've previously spoken about. So Tommy, why don't you jump in?
Sure thing. This is Tommy O'Connor, and I mirror everything that Justin just said. It's great to have all of you guys attending this presentation today. As many of you may know, the COVID-19 pandemic has had very, very strongly negative impacts on not only the global economy, but the national economy and the local economy here in New York. One thing that it's brought up is a lot of new issues that haven't been seen before in the legal context, and especially within the real estate industry and commercial leasing. So one thing that we want to just let you guys know is that the current situation is fast moving. There are updates almost on a daily basis. And I mean, through national legislation, local legislation, CDC guidelines, and other items that we're going to talk about further along in the presentation. But just want to let you know that everything we're saying today is current as of today. But since we are in a fast moving environment, it's always important to stay on top of the news and all of the new regulations and legislation that's coming out. So with that, here's a quick overview of what we're going to be talking about, and I think we can advance to the next slide. So before we start getting into everything, just want to make it clear that there's no one-size-fits-all approach for all of the participants on the phone. Not only do all of you probably have a unique lease, but even if it's from the same form, there's unique facts and circumstances that apply to each one of your leases and your businesses. So the first step that we recommend doing when assessing the current risks and trying to form a strategy about how to move forward is to identify and assemble all of your leases and other critical contracts. So this wouldn't just be your lease document. It would also include any amendments, modifications, notices, etc., relating to the lease. And it'll be important to read each and every one of those because they may be pertinent to the strategy and the approach that you take. And since this is a novel issue, there are many contractual provisions that are typically in almost every single lease that will not clearly address the current circumstances. So alone, in your leases, there's already some ambiguity, but additionally, with the ongoing governmental action, there's some additional ambiguity that's getting layered in there. And that's something that we're going to talk about further along when we're on the New York slide. But customary contractual rights and remedies, it might not necessarily be putting a square peg in a square hole. And just know that you're not alone. Everyone else is in this situation. So once you have all of your documents together, the next step would be assessing your business impact within both the contractual framework and also what's going on with all the regulations and legislation. So this is a very personal and it depends on everyone's unique situation. You might have certain facts and situations that apply to your business, such as you're an essential business, so it's still open. It could be a mandated closure depending on what step you're in the COVID opening process. You might not even have the option to open your business. Additionally, some landlords are voluntarily closing their business to limit risk. So you need to see which bucket you fall into, and that'll help you figure out what sort of strategy you're going to use going forward. Another point we want to touch on is typical landlord remedies and mechanisms that they use if there's a lease default or a problem under the lease may not be in effect. That's not saying that we're recommending not paying your rent, but using the court system as an example, everything's going to be very backed up once things open up. So it's going to even just be harder to get a court date for an eviction. But there is currently an eviction moratorium in New York. So we'll touch base on that a little further in the presentation. Once you've already assessed where you fall, your unique facts and circumstances, we think that the next step would be communicating your strategy with your landlord. And this is something where your specific real estate type, the relationship you have with your landlord, and the type of business you have should influence your approach with how you reach out to your landlord and how you formulate that communication. We're going to go into more detail about communicating with landlords on a separate slide as well. And using an example, retail tenants are likely to be more sympathetic to landlords because retail businesses can't operate without their stores being open. It's much harder for a retail business to work remotely. And then on the converse, if you are an office tenant, there are still some protections you may be able to put in place if you're able to have that building open and the landlord voluntarily opens it. We're going to get into more details about the communications, but one thing we really want to hammer away is that you should engage in open dialogue with your landlord early. When necessary, it should be through written notice, but we'll talk about the process in more detail in a couple slides. We also recommend reserving any potential rights and defenses. And what that means is you don't want to come to a conclusion. You don't want to give up something that could be harmful or give up something that could be potentially beneficial to you in the future to get a quick fix now. You should always be thinking about the long term and what's best for your business in the long term. Then lastly, what we've been seeing is the end result in these tenant-landlord discussions are some negotiated solution, whether it's an amendment, a deferral, something along those lines. And it likely would be a restructuring of the current relationship. So an example of that would be if you're unable to pay rent for 2 months, maybe the term will get kicked out 2 additional months. One thing that we do want to caution everyone is that landlords likely will not be open to a straight out waiver or abatement of rent. And again, all of these solutions that we're discussing really do vary depending on the facts and circumstances of everyone's lease, business, and the current state of their building. And before we go further, also just want to remind everyone that this is largely unprecedented territory. Everyone's in it together, and things are changing on a daily basis. With that, I think we can go to the next slide.
So I know Tommy has mentioned several times that the particular facts and circumstances of anybody's situation is really what's going to control here. So we apologize, but our presentation is really geared to be a little bit more general and also touch upon certain topics that we've seen in our work through the clinic that have reappeared time and time again, but they may not capture everything that would be important to any particular person here based on their particular facts and circumstances.
Great. Thanks, Justin, and thanks, Tommy. So as we move into some of the more substantive slides, you'll see as we discuss tenant considerations on this slide, landlord considerations on the next slide, and as we continue to progress through the discussion generally, you'll see that the observations Tommy and what Justin just said as well continue to resurface. Sometimes they take different forms, but we'll continue to revisit them because it really is, in a lot of ways, one of the most important takeaways of this presentation, sort of how to think about the scenarios, because like Justin said, this presentation isn't a one-size-fits-all, but neither is the legislation that's out there. And so when you have something like that, you know, legislation attempting to be a one-size-fits-all, it sort of fits none perfectly. So just thinking these things through correctly is one of the most important things that we can leave you guys with today. So businesses should really undertake a cash flow analysis, consider liability management actions with landlords and other vendors. The goal here should be to determine the priority of rent as compared to other company liabilities. Some examples of other company liabilities are payroll, taxes, credit facilities, and any potential personal recourse, and to assess what your total liability will be in an event of default occurs under your lease. So here, you know, really try to take a step backwards and really understand and see the forest from the trees. It's important to consider specifics of real estate use. Some important questions include, have operations ceased in your building? And if so, was it because of forced closure or voluntary decision to close? Is the landlord providing services that are necessary for your continued operations? Is the rent below market? What's the remaining term on the lease? So again, taking the question of whether or not your rent is below market as an example, we just want everyone to be thoughtful and think about these items. They can cut both ways sometimes. So, a landlord may be more willing to let a tenant off the hook and pursue a new lease with a new tenant for higher rent if you are a tenant, that's paying below market rent. So, that's sort of an argument that would be in your favor there, and, maybe a win-win for both sides. On the other hand, you might, if you're a tenant who's paying below market rent, you might be, less inclined to want to get out of that lease. You might be wanting to seek some other type of concession.
Similarly, if operations have ceased in the building, meaning like, let's say landlord has locked out all tenants from the building, I think in that circumstance, you might have a better argument for rent relief than you would have if the landlord is welcoming you to come to the office.
Yep, exactly. Other things you should review, you should also review your insurance policies to determine whether COVID-19 losses may be covered. It's not typical, but take a look. You might have business interruption coverage.
One point on business interruption coverage is it would be a rare circumstance for any one of you to have business interruption coverage to allow for money to be received from an insurance company. However, there has been some rumblings with the government that the government is trying to force insurance carriers to pay business interruption insurance as a result of this COVID-19 crisis, although those policies were not written to cover anything like that. I'd say it's unlikely that there's any relief there, but at the very least, applying for that creates a narrative to your landlord that you're doing everything you can to try and keep your business above water.
Yeah, it's a great point. And the narrative point is important, and we'll sort of revisit that a couple times. You should also assess your landlord's insurance. So we revisited this point a couple of times as well, but it's important to kind of, again, take a step back, see the larger picture, understand things from both your perspective and the landlord's perspective. And here, one of the important points is to understand that, the landlord may be able to be made whole by a third party. So, they might be giving you a concession somewhere, but they may be covering something else somewhere else. And that might be a good sign. You should feel free to contact your insurance provider for more guidance here. Another thing that's important is to manage potential health and safety liabilities at the premises. Consult CDC, federal, local industry guidelines. Assess whether the continued operation of your business will be profitable while implementing these guidelines. So really understand what they mean and what that means for you. Review your lease. Assess the merit of any claims for abatement, deferral, termination, risk of non-payment. This is a point that Tommy made earlier, but it's really important to collect all your lease documents and really read them from cover to cover. There may very well be riders or amendments that supersede the language of the original documents and the provisions of those documents. Moving on to landlord considerations. Again, we touched on a lot of these from the other side on the earlier slide, but it's really important to understand your landlord's position as well as your own. So landlords will consider similar factors to the ones that tenants will consider. Some questions you should be thinking about include, what's the viability of the tenant's business following the crisis? Has the tenant had a history of default or disputes? Does the landlord and tenant have a good working relationship? How likely is the landlord to find a replacement tenant in the current environment? So again, think about the below market risk example. Is the tenant or landlord likely to receive government relief from legislative stimulus? So again, here we're looking to see if a party can be made whole by a third party. Before we discussed it in the context of insurance, here it comes up in the context of government relief. Does the landlord have obligations to a tenant under the lease? There might be specific contractual obligations to deliver improvements, provisions of utilities and services, etc. Does landlord have a mortgage on the property? This will come up again, one or two places, but it's important to understand, the landlord may have a mortgage, they may have a loan, they have to service their debt, they have to worry about their own defaults.
In addition to that, their lender may not permit them to provide waivers of any of the tenant's obligations under a lease. So a landlord may sound like they're being very difficult to you, but in actuality, their hands are tied and they just don't have the right vis-a-vis their lender in order to provide you with any concessions, or they have to go back to their lender in order to get permission, which may result in frustrating times for you because you're not getting what you want and the landlord's not being as responsive because they have to go to a third-party lender and get consent.
That's a good point. Assessment of potential remedies by landlord is another thing that we should always be keeping in mind. Practical and legal limitations on landlords' ability to respond, negotiate, enforce. The timing and the volume of requests could be overwhelming to certain landlords if they have many tenants. You may be dealing with a small or less sophisticated landlord, which may present its own challenges. And again, like we've said, just be aware that the landlords are facing their own issues. They're facing this pandemic as well, and the things that they're able to do and have to deal with are affected. Consent from your landlord's lender may be required, as Justin noted earlier, to agree to any modifications or concessions. So keep in mind what they may need to comply with under their financing. Emergency orders are temporarily restricting evictions and other remedies. So as you may know, in New York, there's a moratorium on residential and commercial evictions, so landlords aren't allowed to evict during this time. We discussed this a little bit more in detail on a later slide.
Though there has been some discussions within legal circles about whether a landlord, if a lease permits a landlord upon a default to terminate a lease, whether a landlord can in fact terminate that lease and therefore basically do an end run around the ability to go to court and evict somebody. It's questionable whether or not that eviction would, that lease termination would be binding, but some in legal circles are thinking that it might be. And in that instance, a tenant would have to run to court and get an injunction against that termination. It's murky water right now. I think for the most part, tenants have to rely on the fact that landlords at the end of the day, absent having prior problems with tenants, don't want empty space because that space is not exactly leasable in today's environment. So hopefully landlords will be incentivized not to terminate leases and hopefully to work with tenants.
And so some remedies that may still be available to landlords to keep in mind, they may have access to security deposits, letters of credit, guarantees, lockouts, self-help remedies, noticing cure rights may apply as well. So keep those in mind. And then landlords also will need to focus on potential health and safety liabilities and compliance with governmental mandates. So again, just to revisit an earlier point regarding whether closure was mandatory or voluntary, keep in mind that the closure of a building by a landlord may provide a stronger argument for a tenant to abate rent or terminate a lease. Justin hit this and Tommy did earlier. The current issues in the current environment do not lend themselves to kind of cleaning concrete legal doctrines, and we'll get into this on a later slide as well. There are a few that will hit frustration of purpose and possibility, quiet enjoyment, tenantability, constructive eviction, to name a couple of them. But these things, in addition to help sort of create a narrative that is beneficial in terms of negotiating sort of outside of your lease and outside legal theories, do come into play, and we'll hit those on a later slide.
Great. So now we're going to turn to an overall communication strategy about how to communicate with your landlords. as previewed earlier, we think that the best route to take is an early, direct communication with your landlord. And this is something that shouldn't stop after you reach out and say, I'm having trouble with X, Y, and Z. It should also be an ongoing communication. So as things develop, you should stay in touch with your landlord. And that's a key point in actually executing a strategy you might have for relief. We suggest that the tone you should take with your landlord is one where both parties can seek to find a cooperative solution, where both the landlord and tenant can weather the COVID-19 pandemic. And one thing I just want to point out is that the landlords are also probably facing some economic hardship given everything that's going on. And also a lot of landlords do want, when this is over, to return to having a viable long-term tenant. So we think at the first cut, it makes sense to be cooperative, take a more friendly approach than a hard stance. It also likely makes sense to have a general outreach to your landlord before relying on purely legal arguments or delivering a letter or a document that's very lawyered up. That might not result in the best thing you want. Basically, what we've been seeing when folks are doing things like that, it kind of sets a negative tone for negotiations with the landlord. And what you don't want is for the landlord to take an aggressive approach in response to something, especially that looks like it's a very legal document, if it's coming out of the blue. So we think that it's best to give them a heads up of what your current situation is, and then maybe follow up with something in writing. And if there is anything that's agreed upon over the phone, it's always very important afterwards to make sure that there is some trail of it and that it does end up being written down. So if the landlord says, yes, I agree, we'll defer rent for 2 months and your term will be extended 2 months, make sure that that actually ends up in some sort of amendment or document. That's very important. And when sending any written letters to the landlord, always make sure that you check all of your documents and leases for the notice provisions. There's usually set hurdles you have to jump, whether it's through nationally recognized carrier, whether or not email is sufficient notice, and that should be laid out in your lease documents. So before you are sending a formal letter, please check your notice provisions in your leases. It's also important to note if you have been impaired so far, if you'll likely be impaired, and going back to the ongoing communication point, as things change, it's important to stay in touch with your landlord. If you can't pay any of your obligations or debts, avoid stating a direct admission that is the case. And if you are referring to any obligations, refer to the tenant's obligations opposed to my obligations if you're not personally the tenant. So what that means is if you have an LLC, a partnership, a corporation that's the tenant under the lease, you should always be referring to that entity instead of yourself. One very common occurrence in leases is to have a guarantee where there might be a warm body or an individual that signs it. So you want to avoid saying that you as the individual are also potentially defaulting under the guarantee or any other agreement. Going back to something that we previewed earlier as well, it's important to reserve all your rights and defenses with respect to any potential legal arguments. Since both the legal, statutory, regulatory environment is rapidly changing, you want to make sure that you're not giving up anything that you might be able to take advantage of in the future and might be beneficial to you as a tenant in the future. One thing that you should be made aware of is that non-payment of rent may be asserted by the landlords as a defense to any of your claims. So we do recommend, if possible, to pay your rent and make sure that it's being paid on time. And if you have any questions about your own specific rights and defenses under your lease and under all of your material contracts, it's important to consult your attorney or the city bar for the best methods and the best approach how to do so. One tool that's very helpful before actually getting into the weeds of negotiations with the landlord is some sort of pre-negotiation agreement. In practice, I've seen it in a couple different forms. It could be a more formal term sheet where folks sign it. It may not be binding, but at least you have some sort of framework before you step into negotiations. We've also seen things as informal as a couple emails back and forth stating what both parties want and what the understanding is. That also helps your attorney or whoever's helping you with the amendment draft something that actually applies to your situation and make sure that you get that done right, quickly and efficiently. It's also really important to think about and request what specific type of relief you want from the landlord, and also be prepared to specify what you are doing outside of just the negotiations to get some sort of relief under your lease. This includes items like the stimulus package, going through insurance, maybe making changes with suppliers, staff, furloughs, and items along those lines. So don't be surprised if your landlord asks about what else you're doing. Also, key to note that a lot of sophisticated landlords may request a ton of due diligence materials. So this could include things like financials. So if you're saying I'm unable to pay my rent and you're sending financials, make sure that that statement is accurate. They also might want to see that you have applied for any sort of stimulus package, that you reached out to your insurance broker or insurance company, have contacted suppliers, etc. We can advance to the next one. So before even reaching out to the landlord, it's important to know exactly what your obligations are under the lease. The main ones that you're probably going to be concerned about are the amount you're paying for rent, the timing of rent, and what else is included in rent, whether it's utilities, taxes, you name it. And then you should identify any provisions, if you have it, that permit an abatement or deferral of rent. It's also important to look at any sort of notice and cure rights that might happen if you fail to pay. So it's typical under leases in the default section to say you don't pay your rent. It's not actually a default until the landlord sends you a notice, and then you have a certain amount of days to pay it. One thing that I want to make sure everyone's aware of is, although there typically are those sections, it's not uncommon to see that may only apply a couple times in a certain period of time. So I recently worked on a lease where, although they did have, if they didn't pay their rent, there was a 10-day notice and cure period where the tenant could cure their late or failure to pay rent. There also was another provision that stated if that happens 3 times in a year, then it's an automatic default. So be very wary of that, especially given the fact that the pandemic's been dragging on. If payments have been late, just make sure that you know if that's something that's built into your lease. A lot of folks that we deal with through the small business clinic, they also use the Remedies form, and we want to point out that it's very unlikely that in the Remedies form that a lot of folks use, that there's a specific section that will help the tenant for this pandemic. The one thing caveat is there are negotiated riders that are typically attached to them. Those are usually tenant specific. It may be unusual, but it doesn't hurt to check that. So if you hear that another tenant was able to find some sort of remedy under the Remedies lease, it likely was in their rider, so don't assume that you had it. Another key section of a lease deals with abandonment, or the failure to continuously operate the premises. These typically will end up with a default if the premises isn't being operated for a set period of time. So that's another thing that you should take a look at. This also goes back to the facts and circumstances where did the landlord close the building? Was it voluntary on the tenant's part? So that's another thing that you're going to have to think about. One other major section that we're seeing a lot of back and forth on are force majeure sections. And This is one, like Justin had said, we're going to speak about it generally. In every lease, there usually is a very specified definition of what a force majeure event details. And these strictly, or historically have been strictly construed as to whatever actually is listed in that definition. Things that usually are not available if you're trying to go through a force majeure argument is a failure for the tenant to pay the rent, or excluding the tenant's non-payment. What they typically do handle are other obligations that are non-monetary in nature, and this could be the covenant to continuously operate, delivery of some sort of improvements or construction that you have to do, or the provision of some sort of services that you need to provide to the premises, building, etc. It's also, when looking not only at the force majeure section, but just generally at your lease, if you're looking for some sort of avenue of relief, always make sure and double check that there's not a time limit on when you can claim it. Force majeure is a classic one where there typically is, it'll say 30 days after this happens. Just taking 30 days out of nowhere, that's not a magic number, but there's a typical time limit where if you don't send something within that period of time, you won't be able to seek that relief. That's another one too, where you should check and make sure that you're complying specifically with the notice provisions in your lease. Those are also different from lease to lease, but typically involve some sort of overnight delivery, hand delivery. There'll be a laundry list of things that you can do to comply with the notice provisions. I think we can advance to the next one.
Just one point on force majeure. While it's a commonly used legal term, and most leases have one, it is not something that has a defined legal meaning outside of the specific document. So a document will often define what constitutes a force majeure. Your best odds are either it was for success using the force majeure provision, are either it was super specifically drafted that it included pandemics and government mandated closings, or it was very vaguely drafted that it said anything that prevents tenant from occupying its premises, or something like that. The one caveat with all of this is, much more often than not, force majeure provisions will specifically exclude relief to the extent it relates to something that prevents you from paying rent. So a force majeure will not limit tenants' obligations to pay rent. It will not excuse those obligations more often than not.
Apologies, everyone. So before we get to the summary, we'll talk about lease obligations and issues. We'll continue with that topic. Alternative lease provisions, common law relief. So we are in unprecedented territory. There are novel arguments that may exist depending on specific facts, circumstances, applicable lease provisions. Again, important to distinguish between voluntary closures and mandatory closures. So, if a tenant voluntarily closes, and, we'll put voluntary in quotes here, might not feel voluntary, but if they're not forced to close and they elect to cease operations, including as a result of decreased revenues from, again, suggested, here we put in quotes for you guys, social distancing, work from home, etc. It's unlikely to have a claim for abatement, deferral, or termination on the lease under their typical common law theories. Presence of infections and level of landlord response could raise issues of frustration of purpose, tenantability, and quiet enjoyment. These are some of the legal theories that I noted earlier as well. There's potential room for these types of claims. It's important to consider if the landlord is taking steps to mitigate the chance of infection. That might make the claim harder to prevail if that is the case. But that's also probably a good thing, on the other hand, if not, like I said, the argument could be stronger. But note that the standard for these types of claims require that the claimant meet a very high bar, and that and prevailing on these types of claims will rest in part on a question of foreseeability. And so the question here is whether or not a pandemic like the coronavirus was foreseeable. This is something that we definitely expect to be litigated. I'm sure it already has been. I'm not a litigator, so I'm not up to date on that, but that will, be a very important issue, whether or not it was considered foreseeable. And the question of foreseeability, goes to whether, if it was foreseeable, then, it's a risk that the tenant took on. If it wasn't, then they may be able to seek some relief under these claims. So really quick example, if you rent space to run a gym, the lease provides that the only permitted use is to operate a gym. Your jurisdiction allows gyms to operate, didn't force closures of gyms, but you're not really able to operate, at least on a profitable basis, given the social distancing, CDC guidelines, people just aren't coming in, etc. You may have a claim for frustration of purpose there. For example, in other words, you can't operate the premises for the one purpose for which you rented the premises. But ultimately, again, it's going to be determined by the courts whether or not coronavirus was foreseeable, whether or not these claims are actually something that a claimant can really prevail on. Closure by landlord. If the landlord closes the building and or denies access and services of the premises, the tenant may be entitled to abatement or other relief under the terms of the lease or legal theory of constructive eviction. So, really simply, constructive eviction, the landlord has created a situation, or a situation exists where you're not, forcibly evicted, but you're essentially, given the circumstances, not able to remain. The theories with respect to mandatory closures are similar to voluntary closures, but perhaps even stronger, like we noted. You don't need to make a claim for frustration of purpose, for example. If your gym was mandated to close in your jurisdiction, you can go right to a claim of, impossibility, which is similar, but a little bit more clear-cut. The specific details of New York on pause orders and closures of not essential businesses play an important role in relief under your lease. Again, facts are important and subject to change. Is your landlord required to close the entire building? Is business required to close or substantially reduce operations? These are things to keep in mind. And note that the facts may not fit express definitions or traditional use of casualty or condemnation absent physical taking of space by authorities. So this is something that we wouldn't expect to be available. So just keep that in mind as well.
Great. So now we're going to talk a little bit about what the landlords think about, what their remedies are, and what they're considering. So right now, the first item I want to discuss is the bifurcation between the idea of paying rent and the landlord's ability to actually evict the tenant. In New York, there's a temporary moratorium on commercial and residential evictions, but we really want to hit home that doesn't relieve the tenant's obligation to pay rent or any other obligations under the lease. It just restricts the landlord from proceeding with an eviction, filing, and we're going to talk about this more when we talk about the New York specific regulations and statutory relief. Another thing that I don't recommend that this is the best thing to rely on, but just practically with the court closures and impairment of customary processes that normally would happen if a tenant wasn't paying their rent, it's important to know that is the current environment. It does give the tenant a little bit more leverage because the landlord's running a business as well, and eventually they're going to want to get paid. So even if they do want to kick you out, there might be a bit of backup even when the courts do open. Again, I don't think that that's something you should solely rely on, but it is another card in the tenant's pocket and something the landlord's going to be thinking about when they enter into negotiations with a tenant. I know we touched base on this a little bit earlier too, but tenants generally aren't entitled to self-help. So this means if there's any sort of claims, abatements, or anything like that that the tenant thinks that they're entitled to, you can't use that to offset any of your current rent obligations, which would include both the base rent and any sort of additional rent like utilities, taxes, and insurance. There are some carve-outs, especially with items like utilities that you'll find in a typical lease. Those utilities aren't being provided. That might be an avenue of release that you could at least lower your monthly rent on. But that's, again, depends on your specific lease and something that you should read very closely. Another remedy that landlords can exercise is using any sort of deposit, letter of credit, or guarantees under the lease. So if you don't pay rent, they may be able to take that money and apply it towards rent. Again, this is one that we're going to talk about on the New York specific slide. Also, under almost every single lease, if you don't pay your rent on time, in addition to it potentially being a default, typically there's some sort of interest rate or late fee that's applicable. And it should be important to note that these might be triggered and could accrue during the resolution between you and your landlord in the negotiation. So that's another reason why you should pay rent, in addition to everything we discussed before. And then just broadly about lease modifications, they might include a rent holiday or a restructuring of a payment schedule. So that would mean you don't pay for a couple months, but you might have to pay later at a higher rate, or the term could be longer. But one thing that negotiated lease modifications should include is a waiver of all tenant defaults during the period covered by the modification. Because the last thing you want is to sign a modification, think everything's okay, and then the landlord comes back and says, during this time when we were negotiating a way to fix the problem, you defaulted, and then they exercise some sort of right or remedy that they may have. There also are some other creative solutions. So you could potentially use proceeds from the CARES Act or any other federal, state, or local response package, and that could be weaved into lease modifications and negotiations. One lease that I worked on, we actually did add a contingency. So the tenant did get a rent holiday, but if they were able to get some sort of stimulus package that benefited them, they would pay the landlord as much as they could. And there was a slightly complicated formula we had there, but that's definitely a negotiation by negotiation point. And we touched base on it earlier, but both the landlord, typically the landlord, but sometimes also if the tenant has a lender, there might be some timing issues. So even if you and the landlord do come to some sort of understanding, it's important to note that there may be other third parties where consent is required, or they might need something from the landlord. So just be aware that it may not be the landlord holding things up. They may have to go to their lender. It may take another week or so. So that's something that would be important to ask during the negotiation, so it doesn't blindside you, or you don't think that they're being responsive. And then again, it's important to note that the landlords are running a business. They're getting the same pressure from their own lenders. So they're probably doing some sort of workout negotiations with their lenders if they have them. And then going back to the example we've used a couple times, but if you are seeking some sort of extension in exchange for a modification of your current rent, it's very, very important to understand what sort of liability you're undertaking in the future in exchange for short-term relief. So really, really run the numbers, figure out how the modification is going to impact your business, and you should determine whether it makes sense to enter into something like a lease extension. Just another practical item you should be thinking about is if you're trying to expand, does it make sense to stay in that space for whatever period of time they're throwing out? And I think we can advance to the next one.
Great. So again, apologies, I got a little ahead earlier. We're up to the summary of tenant considerations. I want to go through this slide really quickly now because I know we have a few substantive slides to get to, and then we want to have some time for Q&A. So here, just really quick recap. Things to think about: are you in default? If you are, do you have any defenses? We want to reiterate that you should really look at your lease, including riders and amendments. It's really important to fully understand your lease and has it been amended or superseded. Think about provisions like interruption of services, force majeure clauses. What exactly do those force majeure clauses say? Like Tommy and Justin noted earlier, it's a pure contractual provision, so it says what it says and it means what it says. It's not illegal, doesn't have legal meaning outside of that. Temporary takings provisions, are there quiet enjoyment, access rights, or other similar provisions in the lease? Are you still operating the premises or not? If not, why not? Forced closures versus voluntary closures. What specifically are you requesting? So this just goes back to the point of, be thoughtful, get organized, be strategic, and really understand the larger picture.
Sam, can you just update the slides, please?
I didn't touch anything.
I think we just need to go to the next slide.
There we go. Apologies. This was the slide I was just rattling off on. But again, this was just a quick summary. I know you'll all have access to this. You'll have this, and this is just a recap.
Great. I think these are some of the most important slides and ones that everyone should be aware of. We're going to list all of the very pertinent New York State specific relief and regulations that a tenant could seek. The first one is the evictions and foreclosures. They're currently not permitted from March 16th through August 20th. There is a caveat that the tenant or landlord needs to be eligible for unemployment insurance or otherwise facing hardship due to COVID. So I think there is a hurdle you have to jump through, but I feel like most tenants are facing a hardship due to COVID. One thing that's still ambiguous is whether, if default letters have been sent from a landlord between March 16th through August 20th, whether they need to be resent after the executive order has expired. So this hasn't been definitively determined yet, but the feeling is that they'll have to be sent again after it's expired. And that's something that you should stay on top of, and this is changing on a daily basis, and interpretations are also ongoing. And again, another point really want to hammer home is, although evictions and foreclosures are not permitted, that doesn't mean that the payment of rent is excused. So make sure, if at all possible, to continue to pay your rent. Another one relates to late fees. So this is another New York State specific executive order. Landlords are not permitted to demand any payment, fee, or charge of payment of rent from March 20th through August 20th. So that includes if you're late, like we talked about before, whether it's a flat fee or some sort of interest rate that starts on the day that you don't pay. And then lastly, we have SBDC recommendations down here. Tenants should always review and comply with any sort of recommendations that are listed on the SBDC website. There are also other local recommendations, and those are changing very rapidly as well. So there's some New York specific, there's some New York City specific. So just make sure that you are complying with those as you start to open up your businesses. And then the last point I want to make on this slide is that, again, everything is changing. So it's important to stay up to date with everything that's going on in the news, especially with respect to executive orders, and even on the federal level as well. So just continue to stay on top of it is one of our biggest recommendations. I think we can go to the next one.
There we go. So this slide relates to personal liability. As you all probably know, the question is liability with respect to, company ABC LLC versus, Justin Elliott? who's on the hook here.
Thanks for putting me on the hook, Sam. I just want to point out a number of people have asked questions relating to personal liability and guarantees during the course of this presentation. So if you did, and even if you didn't, now is a time to listen to Sam.
Great. And Justin, feel free obviously to jump in and answer any specific questions. So New York City has enacted a regulation that prevents commercial landlords from enforcing personal liability provisions. So again, that's whether or not you can go after an individual tenant or guarantor personally versus the company, leases or rental agreements with certain business tenants impacted by COVID-19. And the quotes there are intentional. The regulation actually has it in quotes and has an enumerated list of items that sort of defines whether or not a company has been impacted. So, a lot of people may feel impacted and may actually be impacted, but may not satisfy this regulation as defined, as impacted by COVID-19 as defined therein. So we would recommend that you actually click this open. It's easy to read. It's not very long. It didn't make sense to paste them all here and read them, but there is a enumerated list of items. It only applies to guarantors who are natural persons, so human beings, as opposed to business entities, like I said. It's limited to defaults occurring between March 7th and September 30th. So keep that time period in mind.
So the obvious question here is kind of what happens if it's a rent default and you have a year left on your lease and you don't pay rent April, May, June, July, August, September, October, November. The original default started during the permitted time period, but every month there's a new default that is now continued beyond the time period. So the individual guarantor may be excused from whatever default occurred between March 7th and September 30th, but for October 1st rent, for example, it's very possible, if not probable, unless this time period gets extended, that the individual guarantor would not, in fact, be relieved of its liability.
So there is, a lot of holes here, a lot of gaps. This wasn't necessarily written by lawyers or practicing lawyers. A lot of questions here, including what happens if a default commences before the date, continues thereafter, like Justin was getting at. What amounts are landlords excluded from suing for? Are legal fees in there? Other non-recurring costs or reimbursements? What if?
So the text of the bill says specific amounts that an individual guarantor would not be liable for, such as like rent. It doesn't say if a landlord sues you in connection with a default of the lease and then tries to charge you back for legal costs, whether those items are not included. And I mean, there's more items that are not included than are included. There's a list of 3 or 4 items that an individual guarantor would not be responsible for. If you Google or search for this bill, you'll see what those items are. The question is, what was the intention here? And I don't think we have an answer on that yet, but we're continuing to monitor the situation.
And similarly, there may be lines drawn that are sort of emphasizing form over substance, in the sense that they may draw a line on whether or not a guarantor executed a standalone guarantee instead of the lease itself, whether or not the guarantee at issue here relates to a springing guarantee or if it relates to all guarantees. So there will be some fact-specific questions that will have to dealt with and that aren't explicitly covered or clear under this regulation. I don't know if it makes sense, Justin, to jump in with any questions here or wait for them to the end.
Questions that we're receiving live, you mean?
If you had any that you wanted to address directly right now.
I can wait until we get to the end. I mean, about the guarantor here is we're getting some questions about good guy guarantees, which we'll try and address at the end. Although if anyone has specific questions about good guy guarantees, definitely raise them in the chat, and I'll be happy to respond. If the guarantor signs the lease here, I'm sorry, I was answering questions, Sam. I missed where you were. You on 3 or 4?
I went through. Yeah,
okay. Got it. So happy to answer. So we're getting some questions here about guarantees and good guy guarantees. So typically a good guy guarantee, and I apologize that it's called a good guy guarantee. It's a term from a long time ago. Not exactly PC in today's world, but that's what it's called. It basically, under the usual set of circumstances, will say that you'd have a tenant who's a company, and then you'd have a guarantor that's either a parent company or an individual. And the good guy guarantee would permit a guarantor either to terminate the lease, to exercise a termination option on behalf of the tenant, or permit a guarantor to be relieved from liability, notwithstanding that a tenant, which may have no assets, would still be liable under a lease by giving a notice to the landlord of its intent to terminate the lease or be relieved from obligations under the guarantee, and some period of time would thereafter pass. Typically you'd see something along the lines of 90 or so days. And after that period, as long as certain conditions are met, which may include no event of default or rent being paid through that time period, or maybe those conditions don't exist, but assuming whatever conditions there are set forth in your lease are met, at the end of that notice period, at the very least, the guarantor would be relieved of liability, and perhaps the lease would even be terminated and the tenant would be relieved of liability. So you'd have to take a look at the specifics of your guarantee. The one interesting point that kind of has come up because of this new personal liability release from New York that Sam just spoke about is if you have a good guy guarantee that, for example, provides for 30 days notice, and then the landlord and the tenant are off the hook, and you terminate it today, exercise your termination right, 30 days passed, it's inside of the window for September 30th. Question arises, well, if the guarantor, that's an individual, defaults on its obligation to make the landlord whole for rent that occurred prior to the date of termination, including during that 30-day notice period, is that good guy guarantor on the hook for anything? And I think the argument would be no. In that scenario, the individual guarantor, I'm not going to say got lucky, because nothing that's happening right now is lucky, but kind of caught a break there and might be relieved from all personal responsibility under the terms of its guarantee. One other question we received here is, if you have a guarantee and it's a brand new lease, and the guarantee, there's no specific provision in the guarantee providing for a release from liability under a circumstance, the fact that a business is new or that a lease was just signed doesn't necessarily get a tenant or a guarantor off the hook for anything. And at that point, once the contract's signed, you have to rely on the terms of the contract itself. Got a question about the 30-day thing that I just said. So 30 days was an example. Good guy guarantee has a notice period typically. It'll say a tenant or a guarantor can terminate its obligations under the agreement by giving notice and then having a certain period of time elapse. If that period of time, for example, is 30 days and your lease is going to wind up within the window from March 7th to September 30th, at that point, an individual guarantor may catch a break and get off the hook in its entirety, as opposed to if that window was, let's say, 180 days and fell outside of the September 30th cutoff, then in that instance, a personal guarantor would still be on the hook in theory for any rent that accrued from and after October 1st. Anyway, I think we are well beyond everybody's time. On behalf of everyone who spoke today and everyone who helped put this presentation together. I want to thank you all for joining. If you have any additional questions, please make sure to reach out to the clinic. Sign up for a chance to speak maybe with one of us or maybe with somebody else. And we wish you all the best of luck during these trying times.
Great, thank you all. A huge thank you to our volunteer speakers, Justin Elliott, Thomas O'Connor, and Samuel Steinman. We really appreciate your time putting this together for us and extending the time of the presentation. Thank you again to the law firm of Kirkland Ellis for partnering with us on this presentation and on our COVID-19 remote small business legal clinic, and for assisting small businesses during this time of crisis overall. Again, thank you to the Brooklyn Small Business Development Center for co-sponsoring this event with us today. And for those interested in more information on our COVID-19 remote small business legal clinic, or who just want to go through and see if you can get a consultation with Justin, please feel free to register for an appointment on our website. I just sent the link, oops, I sent it privately, but a link to the website page with more information is available. I will send this once again to the entire group. But thank you everyone for joining us today, and be well.